So let me thank you again, everyone, for joining in today, and especially our speakers that are taking the time to participate in our webinar today. It is a special occasion both for CCLS, which celebrates its 40th anniversary today, and for the School of International Arbitration, which celebrates its 35th anniversary. Now, the original plan was to have this seminar in person at our Lincoln's Inn premises, and then in the evening of today to host everyone to a lovely dinner at the spectacular Honorable Society of Lincoln's Inn. But unfortunately, COVID-19 had other plans. So we're hosting this event via Zoom, but we certainly cannot substitute a lovely dinner at the Honorable Society at Lincoln's Inn electronically. But we promise next time the speakers will be in London, we will treat you to some wonderful cucumber sandwiches here. Now, before I leave the floor to Daniel to moderate and chair the whole event, I want to say one more thing. I mentioned that this is also a special occasion about the School of International Arbitration, which celebrates its 35th anniversary this year. It's an extraordinary achievement by any means and any standards, and owes everything to the remarkable vision of the head of the school, Professor Julian Liu. To a great extent, all of us are here today because of him. And I want to thank you for all that he has given to the school and the thousands of students that have graduated from the school all these years. So thank you again, and I'm very much looking forward to listening to the discussion. Daniel, the floor is yours.
Thank you, Stavros. Good morning, everyone, and welcome to this event on the alumni, for alumni of the School of International Arbitration. My name is Daniel Behn. I'm actually one of the newest members of the faculty here, and but I'll be moderating a discussion tonight or this morning about between 4 alumni that have been here and have gone on to have very remarkable careers in international arbitration, and diverse careers as well. One from a secretariat, one practicing at a big firm, one practicing in a smaller firm, and a professor. See the breadth of the type of fields, type of professions that people can go into after becoming sort of specialized education in arbitration. So I think what I'll do is I'll just introduce each of the 4 people that have joined us today, and then we'll start off with some short introductory remarks and then turn it over to get comments on in general. What we want to do is celebrate the school, the vision that Julian Liu had way back in the early 80s, and discuss the experience that each of these alumni members had at Queen Mary, how it molded or affected or influenced their careers, what they learned, any standout memories that they have, and then move into the idea of where education, specialized education in arbitration, how the community values it, is it necessary, what are the advantages of it, and then looking into the future about how the pandemic, how specialized education of this kind will, how it will adjust to a future scenario where there will either be more arbitration or less arbitration, depending on who you talk to. So we'll start with Professor Stefan Kroll, who I've learned in the last few minutes about. He was here in the early 90s, so one of the first graduates of the school, and he can tell you more about that. He's gone on to have a very successful career as an arbitrator, but also as a professor at the Bucerius Law School in Germany, and is well renowned primarily, significantly as the director of the Wismut for the last almost a decade now. And then we can turn to Alice Fremuth-Wolf, who is the Secretary General of the Vienna International Arbitral Center, which is a significant center based in Vienna that does a lot of work in commercial arbitration. I don't know exactly what the caseload is, but I think it's, from what I remember, it's been growing in the last few years. Then we will turn over to Maarten Draye, who is a partner at Hanotiau and Vandenberg, which I don't know, maybe Maarten, you can tell us a little bit more whether you sort of tend to think about these firms like that as boutique firms, but I don't know how people that practice within those type of smaller specialized firms actually consider themselves in that way. And Maarten, I believe, was here in the mid-2000s, which makes him the most recent of the graduates of the School of International Arbitration, and is quite involved also with the alumni association associated with the school as well. And then lastly, we can go to Sabine Conrad, who is a partner at Morgan Lewis now, based in Germany, very prominent counsel and arbitrator in doing a lot of investment arbitration cases, and who was at the school, I guess it would have been the late 90s, I believe, and she can tell us more about exactly your practice and your time at the school and what you thought of it. So we'll now sort of turn it over to this first question about what will just sort of lay the groundwork of what do you remember about your time here? What was it like? What are some of your memories? What did you gain? How did it cement your future career path? What happened after you were here? Was there further education? I think Alice went on to get a PhD afterwards. And just to lay out, sort of give us an idea of how these very successful careers in arbitration happened. So Stefan, do you want to start? And then we'll pass it around and then come back for a second round.
Thank you very much, Daniel. Thank you, Stavros. And also thank you, Julian, for setting up the school. When I came in the early 90s, and they were all joking about that already, that I'm basically the grandfather of the whole part here. I came as a PhD student in arbitration already, and the school was one of the very few universities where you could go have an arbitration class. And I still remember the Monday evening trips out to Milan. And for me, the school was in so far very mind-opening that I came as a German student, immersed in a lot of theories, everything very structured, and you had a number of theories, and then you had one solution. And then I entered the class and had done some work before, and I was waiting for solutions as well. But Julian only asked questions, yeah? And that drove me at the beginning completely crazy. Yeah? I was always sitting there waiting for the final answer then, but there was no answer. As I said, as a student, that drove me crazy. Nevertheless, with the later contacts with Julian, yeah, you realize that the Socratic method for teaching purposes has considerable advantage, and it broadens your thinking. In particular, most of the education, undergrad education, is really national, and there was the first time already at that time that you were immersed in a group of international students coming from all over the places. Yeah, there was a strong Germanic input from Switzerland, Germany, Austria, but we also had a lot of students from Nigeria, a lot of students from Latin America, and we all had different approaches to the same problem, and that was the fun part. And also to see it at the time, we still had at the beginning UK arbitration, English arbitration, which was primarily done by Professor Adams. And there was an interplay between Julian and Professor Adams, which was quite interesting to see also see the breadth of arbitration. You have the really international cases, but you also have the national cases, rent review cases, or labor cases, which were the specialty of Professor Adams. And for me, as I said, the interesting part was having this international community and having people just asking questions. And at the time, Julian had just published his Immunities of Arbitrator book. That was how I realized that there is a case. And at the time, I was a student at the LSE, but managed to convince my supervisors that I could take a class there and also take it for credits, which at the time was still a little bit difficult, yeah, because there were other classes which were conflicting. But for me, that was one of the very interesting parts of the intercollegiate LLM. And the other thing which was there that I learned that you don't have to take anything for granted. You come with an approach, and but people will have the same problem, but come have a completely different approach. And in the end, you realize, wow, their approach to it may be even better than the one you used to. Yeah, it went on then writing the book together with Julian and Lucas, and probably we had the same long discussions between the German liking theories and liking answers, and Julian trying to be very open to everything. And there were fond memories also. Nora was in the end there to mediate a little bit between the two of us. But for me, it was a real development from the traditional, very German approach to a much broader international approach, which I also use for my teaching now. I provide more answers than Julian probably did at the time, but still I raise much more questions than I can answer.
Thank you, Stefan. I would just briefly, how has German education and arbitration changed over that period of time from when you were at school to where it is now, would you say?
When I was at school, there was no education in arbitration. There were very few universities which had at all a class in arbitration. Now, in principle, every German university has a class in arbitration, and I would say 70% of them are taught by practitioners, so which come in and give a class just on arbitration, and only very few are taught by full-time professors, but all of them are also sitting as arbitrators. So you see the practice involvement in arbitration, but at the same time, it has a lot of theories underlying it. So it's what I really like there. It's a mixture of both practice and theory. And if you have only one side, it would be boring, whether it's the purely university side or whether it's the pure practice side.
Thanks. Alice, do you have a few comments or memories of your time here?
Yes, yes, absolutely. Well, first of all, thank you, Stavros and Daniel, for having invited me to speak today. It's a great honor for me, and thank you very much also to Julian, especially for all he has done for the arbitration community and for myself personally. Well, my story is sort of a bit similar to Stefan's. I got first in touch with arbitration in 1994 when I did an internship in an Austrian law firm while I was still a student. And it happened that the partner that I was assigned to was counsel in an ICC arbitration, and our client was an Italian tractor manufacturer with its seat in Milano, having arbitration against his Czech counterpart. And it happened that I even got to go with this partner to Milano for the client meeting, and we had nice dinner in Milano with some shopping attached, and I just knew this is it. That's something where I really wanted to dig into. I was caught, and when I finished my studies in 1995, I moved to being an assistant at the Institute of Civil Procedural Law, because that was sort of the natural environment, I thought, for arbitration. But I was disappointed because, as Stefan mentioned, back then, there was no course for arbitration, and even the professors that I was sort of assigned to, they were kind of laughing at me when I said, I think that arbitration is something you know, up and coming, because it really didn't exist in Austria back then, or only on an ad hoc basis. So I thought, okay, if I really wanted to learn something substantial about arbitration, I have to go abroad. And then naturally, the School of International Arbitration of Queen Mary caught my attention. And yes, I did my studies there in 1997, 1998. And I really had the privilege of, you know, the late Professor Adams and also Julian Liu to be my teachers. And I really have to say that was the best course that I've ever chosen. It was thought-provoking, challenging, entertaining, everything basically you could wish for as a young and hungry student, with a lot of questions, not so many answers. And we were, you know, really challenged all the time to think about answers that we haven't thought before. Yeah, the school was back then in Miles End, at a not very fancy location, but nobody really minded, because we were filled with the thrill and with the enthusiasm that Professor Adams and also Julian Liu conveyed to us. So all I actually know about arbitration stems from back then, the basis. So when I returned from London, first of all, I was broke, because the pound back then was so high that I really had spent everything that I had, and I just felt that the academic world probably is not for me. So I ventured into private practice. I did my bar exam and specialized in arbitration, and even finished my PhD afterwards in the field of arbitration as well. Passed the bar exam, and then started getting my first appointments of arbitrators. Yeah, and how did I end up in the position where I'm now as Secretary General? Well, you know, it was the time also for my private life to advance. I had 3 kids, and I was just, you know, thinking that probably staying in private practice is really difficult to combine. We all know the working hours. And then there was a chance, this position popped up, and I just took my chances. And since then, I'm heading the VIAC, and I'm very happy. And let's see what the future is going to bring.
Thank you, Alice. How long did you feel that it was a natural progression to make that jump to an institution? I mean, at what point, by that point when you first took the job there, were you already familiar with had you acted as counsel and arbitrator before at that center? And is the community in Vienna quite tight knit in that regard? And once you get to know people, yeah, how do you do that? How do you go from practice to doing that?
Well, actually, as it was in my case and all through my career, it was by chance. It was pure luck, you know, and I really didn't plan for it. I just realized when I was, you know, acting as arbitrator and counsel, and I, you know, had this family sort of scenario in mind, that probably I needed to adapt somehow, because I couldn't figure out how to combine. And then simply this position popped up. I was approached, and I just thought, okay, let's give it a try. And yeah, I just fell into it somehow, and never regretted it. Well, maybe sometimes, but not really.
Thank you very much, Alice. And Maarten, what are your memories of your time here?
Thank you, Daniel. Well, first of all, also allow me to thank you and Stavros for the invitation. It's too bad that we cannot have the fancy dinner tonight, and we cannot all see each other. But I think it's nice that you use the technology and at least bring us all together and have a chance to have to be in contact. And I can only second also the warm thanks that some people have given before to Julian Liu for his vision and for setting up the school. And despite what he has reached, he's always very keen to help his former students to see how he can advance you. And it's something I personally appreciate very much. And I think a lot of you will have the same experience. So just wanted to share that. And just as testimony of that view, how I got in touch with arbitration is, as you mentioned, I was a little bit later than most of them. I did my LLM in 05, 06, but even in the early 2000s, and I did my LLM right after my Belgian legal education. I did a year of economics in between, and then I wanted to specialize further in law. But there was really almost no, even in the early 2000s, arbitration was not something that was that widely taught, even at that time. I remember in civil procedure, there was a small chapter at the end of the course in Belgium saying that, oh, there's a book 6 on arbitration in the procedural code, but we're not going to deal with that. And we just had Professor Hans van Hout, who is one of the famous Belgian arbitrators, who I had a few optional courses from, and he, at the end of his courses, he touched on arbitration, so that sparked my interest. When I came to London, it was still the times of the intercollegiate LLM, so I think we had the choice of roughly 130 courses. So I had made a whole list of different courses, because you could try them all out in the beginning and see what they're all about. So I'd made my potential wish list, and I must say that the first class of the International Commercial Comparative Arbitration course, which was taught by Julian and Lucas, they did a very good job introducing the course, because everything that sparked my interest in my classes in Belgium was sort of further sparked, if you will, during the introductory course. And then Angie Raymond and Stavros also sort of pitched the idea that you could participate in the Wismut, which for me was then completely, that sealed it for me. So I think that the arbitration course was the first one I marked down as one of my final 4 choices in the end. I did a bit of comparative research, as I said, and I ended up taking 3 of my 4 modules at the School of International Arbitration. So I think it's fair to say, I think that the introductory course is maybe a bit of an epiphany, if that's the right word, and then taking the courses through the year and being part of the Wismut, for me made me decide that this was something I wanted to advance my career in. And so I did that. I did after graduating, I did an internship at WilmerHale in London for a couple of months, and then I started at Hanotiau and Berg in Brussels, where I still am today. Maybe just to answer your question, Daniel, it's a boutique firm. What we do, of course, we have Hanotiau and Berg, who...
Do you refer to yourself that way? Is that how people refer to it, or do they consider that to be an odd way to refer to a small firm?
No, I think for us, the way we look at it is, so we specialize in arbitration and litigation, so really dispute resolution. And I think we're a bit comparable to a dispute resolution department in a bigger firm, but set up by itself. So dispute resolution is all we do. And obviously some of my partners only by now only sit as arbitrator, but we have quite a bit of counsel work as well. The only field where we don't do counsel work is in investment arbitration, because the issues are so limited, and to avoid issue conflicts. So there we're more careful, and we usually don't get involved. But so our focus is really dispute resolution very broadly. Doing from litigation to arbitration as counsel and arbitrator work. Maybe just a few thoughts on the Queen Mary's style of teaching, because I think Stefan and Alice touched upon it. I had a bit the same experience in Belgium, that it was very knowledge driven, very encyclopedical knowledge, which is something I personally hated about law school in Belgium. And for me, it was also eye-opening that the teaching was more on spotting the issues and make you a better lawyer. You were not necessarily, I mean, they expected you, of course, to bring an answer by the time it got to exam time, but it was not so much, recite pages 530 to 532 of your course book, but really spot what are the issues and come up with a way to answer it. So it's really, I found it a way of teaching you to be a better lawyer, really to spot what is there, what could be an issue from a legal perspective. And so for me, I found it very useful for my later career. And then for me personally also, since I was someone who did not have professional experience before doing the LLM, the Wismut and learning how to build up an argument both in writing and orally was really a great way. I think it's a very realistic way to learn how to do that. And if you have the chance to do that in the framework as a student, as opposed to as a junior lawyer, I think that really helped me later when I had to do the real submissions, that I had done it before.
Yeah, that's really interesting. Oh, sorry, Maarten. I didn't mean to interrupt you. I was looking through everybody's past history, I guess, so to speak, before this event, and one of the things that I did see, and you were the one that I hadn't uncovered yet, but there is among all of you were involved in the moot competition at some point, and maybe in Stefan and Sabine, you're still involved, and Alice, you coached it for a number of years, I believe. Maarten, were you involved any more with the mooting afterwards? And do you think that there's something about that opportunity to be involved in one of these kind of competitions helped you, catch the bug, or to know that this is something that you wanted to do as a career?
Yeah, for me, as a participant, I think it definitely helped me in catching the bug. And I assisted coaching at the University of Leuven, where I'm from in Belgium, after I participated. So then it's more about trying to pass the bug. And now in recent years, we have organized some tests, and we've invited some practice runs for local Belgian teams, and we have a Brussels Fremuth that takes place in Belgium most years as well, where you participate. So I think it's a chance to give back a little bit, in thanks for the time when you were a participant and people passed on their knowledge to you. And I think it's a great experience, and I'm always incredibly impressed with the level of the quality of the level of the students. And as a former participant, you know what went into it. So it's really always, it's really fun to see in action. So I enjoyed it as a participant, and I enjoy trying to participate from time to time now as well.
Great. Thank you, Maarten. Sabine, can you hear me? Yeah, you're there, sorry.
Yeah.
Sometimes I can't see where the different panels are at the different points. Yeah, what about your thoughts on that, on your experience in your relationship with the school, and at what point in your career were you already at when you did the LLM, and any memories that you have, and that'd be great.
First of all, thank you for making me 5 years older. No, I did the Queen Mary diploma in 2005. I think I may be actually the only one on this panel who's done the online format of the course. And Stavros will know when it started. I think it was one of the very first years. So we got our assignments, writing articles and writing discussions and exploring the relationship of arbitration and human rights and other stuff. And then coming to London, I think we came to London once, and we had an award writing weekend in Vienna, which was very nice. What struck me as interesting in that course, it wasn't just lawyers, which may be different today. There was a very strong contingent of engineers, so non-legal people who had no idea about how to write an award, no idea how to write a legal paper. So it kind of puts things in perspective that, these are the people that most likely not as arbitrators, but similarly educated people as experts, which you have to face later on in your career. And that one big skill is actually translating between lawyers, counsel, arbitrators, and experts who have no idea, unless, they're professional valuation experts and sometimes like to think of themselves more like lawyers than they really are. But that, a lot of this job is trying to translate, to interpret for people who are not lawyers. Kind of the cultural translation interpretation exercise between lawyers and non-lawyers, between people trained in, French-based thinking legal systems as opposed to German legal systems and English ones. So you will notice I don't divide between common and civil law, because I think to some extent sometimes the English are closer to the Germans than the Germans to the French, having lived and worked in Paris for 4 years. And the Spanish-speaking nations have a completely different outlook on maybe even the same provision of a law or of a treaty. Good example, for example, is Article 21 of the Venezuelan investment law, which older people might recognize. So if you talk to people who've grown up in Spanish and in Spanish-speaking legal systems, you got an answer, well, this provision is absolutely clear. And then you had the English, German, French educated people on the other side with it. There's no consent to arbitration in here. Where? And the Spanish speakers say, yeah, there it is. We don't see it. So it is a good school, not just of arbitration, but of life, what Queen Mary is offering to the students. And, as you mentioned, Daniel, I'm not just still involved in the moot court, but kind of run one.
Yes.
And the prize for the best participant is a scholarship at Queen Mary. So I must have somehow liked my experience in Queen Mary, because otherwise I might not be doing that. So I want to share the experience I had at Queen Mary, the great experience with the kids, the students from all over the world who go through the moot court, who really work extremely hard, for whom it's often very difficult to participate. This year we were smacked in the face by Corona. We would have had our first team from Afghanistan. So I hope in the new normal, but which hopefully will by next March be again the old normal, we'll have an in-person moot court, and we'll be able to send the next scholar to Queen Mary.
Let's cross our fingers. What do you think? I mean, that's maybe more of the second series of questions to talk about, but what will these moot competitions this year? They've been postponed, canceled, and what do you think is the next move? Maybe Stefan, if you wanted to say something about that as well.
Yeah, I'm not a big fan of online moot courts, because for the students, the important part is, for them, for us arbitration practitioners, are the conferences where, as we joked before, we're not coming necessarily only for the talks, but mainly for the coffee breaks. So the in-person, face-to-face meeting, getting to know new people, which online doesn't work as well, is something that our older generation has the conferences for. The family meetings of the arbitration community. For the students, especially those that don't have the privilege working for one of the arbitration firms, moot courts are, and courses like Queen Mary, but more so moot courts are their opportunity to get into the community, become part of the community. And without online, without in-person meetings, without in-person moot courts, it will be much harder for people from developing countries. I know this sounds counterintuitive, because the threshold of participating in a moot where you don't have to travel, it sounds easier online, but you will reap maybe 1% of the benefits. You may have the learning part, you have to invest a half year into the case and, write legal arguments, do your research, study, argue, which is, very, very, very important. But especially for students from outside the arbitration centers, getting together, seeing people, proving your mettle, proving that you're good, getting somebody interested in you, that they offer you this internship, that they, you may win the scholarship. You go to the Hague Academy, you become part of a truly global and wonderful community. And without without the personal experience, I think mooting is not impossible, but it's not the mooting that we all love.
So will you not? So will will moot courts take place next year in any kind of online form? Stefan, what is going on with the Vismoot, and what are the plans, at least the sort of tentative plans about the following years? Sabine, you can answer after that as well.
I agree with Sabine, yeah, that you lose a lot if you cannot meet in person, if you don't have the oral hearing in person. For us, we took the decision at the time that the alternative to the excellent in-person meeting should not be you don't meet at all. And since the students had done all the work, we decided that we would do it online. And from the feedback we received from the students as well as from the arbitrators, we decided that we hope that next year is going to be in person again, but we have a dual planning in a way that if it doesn't work in person, we will have set it up that we can have an online moot again, because as Sabine said, there are several issues. On the one hand, there is the personal issue with the meeting people, but on the other hand, you have the learning, writing and presentation skills. And I think you can train that as well, and to at least offer the students the opportunity to do that in an environment which is fairly close to reality. We decided that we will have next year's moot definitely, either preferably in person in Vienna, and if it doesn't work, we will have it online again. The issue is always, since we had it done once online, you will have a lot of deans who say, oh great, can my team not participate generally online? That was one of the big concerns we had, that once you have opened the floodgates, you will have people saying, let's take the education part and forget about the other part, which is, I would say, as important as the other one. I still think it's better than nothing, having it online. Sabine mentioned the teams from Afghanistan. We have a quite interesting group which is funded by the American Department of Commerce. They have a group, they fund up to 20 teams, which they teach all over the world, and also 4 universities from Afghanistan, where you would say, wow, you're surprised that there are people considering actually participating in a moot, from all the news you hear there, and when you hear their stories, how important it is for them, and then you see that they send an all-female team from Afghanistan. If you had asked me, that would have been the last place where they're sending a full female team. But to allow them, at least to get something out of that, we will have it online again. And also, when you look at the Afghan Arbitration Center, these are all former MUT students. They were so into that they set up their own center now and trying to build up something which is parallel to the court system, which, at least what I was told, is not comparable to the court system we have in the UK or Germany or in Europe.
Yeah, so Sabine, did you want to comment on that, on what you guys are going to do next year? I should have been more explicit, I guess, to everyone that isn't joining. Sabine runs the Frankfurt moot, which is typically an investment arbitration. Is that correct? And has for many years. And Stefan has been called the director of the Vismoot competition? I think is for a number of years now. So I think there's actually that the mooting is the one common thing among all of you that stands out. At least it did when I was doing a little bit of background research. Sabine, did you have a few comments?
Yeah, I mean, when Stefan mentioned Afghanistan and the female team, I remember that the Jessup team of Afghanistan was in a hotel practicing for the national rounds for the Jessup in Afghanistan when the Taliban entered and raided the hotel, and the students were hiding under the beds. Their computers stolen, their books stolen. And I remember that at the Frankfurt investment arbitration moot, we were setting up a collection of and donation of books and money in order to get the team, refurbished again with the materials they needed to participate. I mean, these kids are the most courageous, those are participating from those countries. And I can understand that, you know, for them, online is better than nothing. We haven't made a decision yet for next year. I mean, our mood is somewhat different from the Wismut, because the emphasis is less on memorial writing and more on advocacy. And while online advocacy, you know, something we're doing right now, for example, is a special skill set that you also need to develop, but you know, standing up in front of your peer, or sitting down in our case in arbitration, but pleading in a big hall of people in front of arbitrators that, you know, are household names, it is a completely different atmosphere. And the model that there are 9 problems in the case and only 3 are being pleaded in each hearing, the students will only see the topics for their session an hour before. It gets more complicated with online. So I think what we may be doing, if we can't, you know, we all knock on wood and hope for the best. If we can't have a global competition, we may have, you know, individual smaller events on each continent, but we haven't finished our thinking on that one. But I mean, as you say, mooting is the factor that includes all of us. I actually just realized that all of my associates have done mooting, participating, coaching, and now judging arbitration competitions. So that seems to be the one common factor that everyone has.
It's interesting, yeah. And actually, this provides a good segue into the next idea or theme that we'll probably just get through this when we've got about 20 minutes or so to keep talking, is the sort of combining the where arbitration education is headed, what will the effects of this global pandemic have. We're seeing already, as you mentioned, about the effects on the moot competitions, and of course also for us in teaching, and whether the new normal is going to be a combination of in-class and recorded lectures, and exactly how that'll work and how everything will work is all up in the air for everybody, I think. But there was a question that one of the people in the audience here, Ian Gaunt, was talking about, that actually that the Wismut is, if you do it in an online version, maybe there's a parallel with the fact that we may be, at least in the short term, needing to educate young practitioners in how to deal with the online atmosphere. If we're going to move to online hearings and arbitrations being conducted with no travel. So if we'll just go around the table again, and just thinking about sort of what your thoughts are at this point in time, when we're sort of right in the middle of it, going into the summer, and have a new year starting up in September, and where we're going to be and where we might be going. Stefan, your thoughts?
Yeah, that was actually one of the reasons also why we decided to make the moot online, yeah, because when we discussed that before, we heard from a lot of colleagues who said, it will not work. I've done my video conferences, yeah, and don't even try it. And a lot of them were experienced practitioners. And when we did it later on, some of them came back and said, okay, I have now seen it works, yeah, there has been movement, and we will change that. And what you see now, I think most of us who practice arbitration have seen the first hearings being rescheduled, yeah, hoping that we could have it in person. But then with the next hearing, probably saying, okay, if we cannot have it in person, the alternative is delaying it. And we will have hearings then slightly differently organized online. So what Ian describes there is one thing we had in mind when we decided to go online. And I think it will change the attitude. Yeah, that's at least what I see from my arbitrations, that people are much more willing also to perhaps engage in this type of hybrid forms where you say the main witnesses, the central witnesses, 3 or 4 central witnesses, they should appear in person, and the other witnesses, which we may need for certain points, they may do it virtually. Again, with a German background and an interest very often to reach the settlement, that is one thing which you probably will lose out on. Yeah? If you want to get the feeling for the people, they should sit largely in the same room, yeah, and then you realize whether there is a chance that you speak to the people and say, have you considered, in light of what you've heard today, sit down, and can the tribunal be of any help for that? But I think largely the COVID crisis will be a chance for arbitration, yeah, because in the UK you have a very flexible court, yeah, which has little problems apparently with data security, data protection, that they go online via Zoom. Yeah? In Germany, even if you talk about schooling, people are concerned that Zoom is not safe or whatever. Yeah? Where you say you hand out everything to everybody, yeah? But then you're concerned about Zoom. And for a court, it's really difficult. The equipment here in the German courts is hardly existent at present. And I think many companies which have cases now in the courts would say, okay, if they cannot move, if they're restricted by whatever protection rules, why are we not moving to arbitration, which most of the institutions have been very fast movers acting, setting up their systems. You have the arbitration centers. So I think the crisis and the flexibility shown by the institutions, shown by the players, will actually be a chance of increasing the popularity of arbitration.
Alice, do you agree with that? I mean, do you see that happening already, or where do you think the path will lead?
Well, first, I totally agree. I think that was always the advantage of arbitration, that we are flexible, that we can adapt quickly to changing circumstances, much less than the courts can do, because they have a much more, enshrined structure. And I think this is really the selling point, that in times when arbitration was under attack and was being criticized, I think now we can again see the values of arbitration, and that we can very quickly make things possible and make things work just by adapting to new situations. And then in terms of sort of what advice I would like to give to young arbitration lawyers and practitioners for the future. Well, first of all, I think it's really important to bear in mind, and I think that touches also on the question, do we educate too many arbitration practitioners for the market? I think it's really important for everyone that wants to move into arbitration is not to specialize at the too early stage only on the procedural issues, because the arbitration procedure is one thing in your toolkit that you need to have, but it's very important to have the broader picture. I think it's important to have industry knowledge, to involve yourself also in substantial matters and areas, because it's difficult to have young arbitration specialists who have not seen nothing else except sort of the inside of an arbitration room. I think this is even dangerous. But of course, again, when it comes to education in arbitration, I think it's still good to have specialized courses as this one, because not everyone that is being educated in these courses in arbitration will end up as an arbitrator or as a counsel. They will go back doing in-house work. And I think even there, it's really important for people to be aware of the toolkit that is available, being arbitration, mediation, or adjudication, or whatsoever, to also implement it in the undertakings where they are going to work. So I think it can never be too much education, and whatever people do with it, I think is to be seen. So that would be from my side.
That's great, Alice. I mean, I think that's great advice. I wonder, with a lot of international arbitration, you have definitely specific bodies of law that that you need to know, and probably there is less of that being taught in arbitration schools, in particular, say, English substantive contract law. But how do you find that balance in educating someone that, especially a school like Queen Mary, where you have people from 30, 40 different jurisdictions coming and trying to, teaching the substantive law is, in investment law, it can be body of international law, but I mean, it's just the breadth of the industries of that kind of specialization. I guess people have to do a lot of that on their own. I know Stavros teaches a construction arbitration class that's very popular. That's one type of area that you could have classes in, but yeah.
I still think that, you know, classes in schools like the School of International Arbitration for the procedural part is important. And I would not, you know, even specializing in construction arbitration, I'm not so sure whether I consider this to be a particularly good idea. I mean, investment arbitration is, of course, another field. I think it's good to have a course that gives you the overview of the procedural part. But then again, if it comes to substantive, I think people have to do it on their own, on a particular field that they're interested in, or maybe by chance they are falling into. This is not something that the School of International Arbitration can do. I think I just wanted to raise the awareness that it's not sufficient just to do a course in international arbitration and then, you know, go out and say, yeah, I'm gonna be the next arbitrator. There's much more to it.
Thank you. Maarten, is the breadth of your practice, I mean, are you looking at many different substantive laws all the time in terms of that, but then also your comments on the sort of where education?
Yeah, I think that's part of inherent. I mean, my practices makes also still do litigation before the Belgian courts, because obviously there we focus more on Belgian law and also the ones where we act as counsel. People usually come to our firm and there's some element of Belgium involved, but of course when you sit as arbitrator in my younger days as tribunal secretary, you come across different substantive laws. So it's that I follow Alice that those elements are something you will not necessarily learn or be able to teach or even be able to offer a program. But I think one thing that where the school stands out, at least in my days of the intercollegiate LLM, was that a lot of people took arbitration but also focused on different parts. So I ended up being one of the persons who focused a bit more on arbitration courses, but a lot of my friends actually took arbitration because they were interested in it, but took other classes in banking and finance and so on. And I think to me, that was one way where Queen Mary stood out a little bit towards those very specialized programs where everyone only focuses on arbitration, which I'm sure has certain advantages as well, especially if you've, for example, practiced for a while and you really want to focus on arbitration work. But I think it was for me, I think it's a lot of added value. Even a lot of my friends who went into very different careers did not continue in arbitration, but it's still important that they are aware of the possibilities, aware what if there's a dispute in their field of law, that arbitration is one of the tools that they can use to resolve that. So I think that's one way, at least for Queen Mary, to sort of have a different approach from many of the other schools, that they offer a very high quality arbitration course, but also to people who do not necessarily only want to focus on arbitration for their further career. But the comment that you made that people said, where are you all? Aren't we educating too many people in arbitration? That was a comment that was made to us when we attended as students the 2005 Freshfields lecture that some gentleman came and told us, what are you going to do and what do you think you're going to achieve? So, I mean, I think it's not a new problem. I think whether you achieve it is, and that's maybe coming to the advice part, I think a lot of it depends on you, if you have the dedication to do it for younger students who want to practice what they have learned in arbitration courses. There's an element of dedication, there's also an element of luck. I think one thing that I would always advise people is there's not one path that leads into arbitration, I think. there's of course the big firms, and I remember a lot of my classmates at the time, they all want to go for the few firms, but it's true that the places are not unlimited there, but there's other ways as well. I went back eventually to my home jurisdiction. And when I started my firm, I practiced almost only litigation. So I went to a boutique firm, I started with litigation, and now the majority of my work is arbitration work. But so it gradually builds up. And I think that practice as a litigator, even though if it's a different game, gives me certain qualities as well that I can use in arbitration. A lot of my colleagues, for example, of my younger colleagues, we do hire a lot of people, especially for the arbitration cases that we're working on, who come from an arbitration background from a school like Greenberg or one of the different programs. But I have an excellent colleague who took a very different route and who first practiced into different fields and then and now is one of our excellent senior associates and who came back with that further broader knowledge. And I think, so my advice would be that there's not one way in arbitration, and there's other skills that are very useful in arbitration, management skills, technical skills with the COVID-19 crisis, all the more, even skills on how to present arguments and so on, if you're very good with software documents. And so I think there's different skills that you can develop that can be very useful, and then you need to keep an eye out for possibilities that come along your path and take them and go the extra mile.
Thanks, Maarten. Just briefly, are most of your hearings upcoming all online now? Has that been a total shift, or are they suspended, or what's been your experience?
I think our experience is a bit similar to what Stefan said in the beginning. Of course, people didn't know how long it would last, and in a lot of cases there were postponement, but then more and more, people see, and I think the Vismuth did a great job in showing that it can work. We, within the firm, immediately we put a lot of attention in trying to educate ourselves on what is out there, what are the possibilities, what are the challenges, because of course it is a challenge, but I think that's where we can show as arbitration practitioners also that we can be flexible to the extent that the case allows it, and try to look for different solutions and see what the possibilities are out there. So now a lot of the hearings are moving online. I have one hearing as an arbitrator coming up where parties do insist on, now that travel bans are somewhat restricted, we'll have a hybrid hearing because not everybody is able to travel, but the parties still want the core of the parties and myself as sole arbitrator to be present in one room, but to have witnesses heard virtually. So we'll adapt and we'll see how it works. But I think, as it was mentioned before, that's where we can show maybe faster adaptation than the courts in many countries will, and show our additional work to give the parties to meet the expectations that we can help them solve their disputes.
Thanks a lot, Maarten.
Daniel, can I just briefly make a comment in relation to the valid point that was made about how many young practitioners now come into the arbitration field and how difficult it is for them? Indeed, there is now a plethora of LLM students specializing in international arbitration. But at the same time, I think what is also important to remember is that compared to 30 years ago, now there are many more jobs about international arbitration. They have many arbitration departments in all law firms, especially international law firms, that they didn't exist. But when Stefan Kroll did his LLM and his PhD in arbitration, you have many boutique firms that now specialize in arbitration that, again, didn't exist back then. You have many positions in many arbitration institutions, which, again, they multiply and they offer new opportunities, different pathways. Also, many universities now offer specialized lectureships and professorships on dispute resolution, which, again, you didn't have this kind of career path 30 years ago. So yes, there's probably more students that are coming out, but at the same time, I would say there are more opportunities, more meaningful opportunities for people to develop their careers. And I think it's always going to be competitive, but I think it's wonderful and thriving field. And I think students shouldn't be deterred from spending time to specialize in international arbitration.
I completely agree. I think that there actually probably isn't a saturation point yet, and maybe actually this whole pandemic is an opportunity for the arbitration field to expand even more because of the attributes that it has. I think, yeah. So thank you, Stavros.
Can I also say something on that one, because teaching and educating students is also something I do, and I get the concerns from my students as well. Yeah, and then I tell them first the thing Stavros has just said. There's more arbitration work out there. But second, most of the things you learn in a proper arbitration class, if you have the theoretical background as well, is relevant in principle for whatever you do. Yeah, we see more and more that you learn the general technique of conflict issues, whatever, and not the substantive law, because it changes all the time. And so if you have done a proper arbitration course, you have this type of, you learn a little bit of management skills, you learn a lot of conflict of law questions, which arise on the substantive side as well. And that's what I always also thought is one of the big advantages of Queen Mary, that in principle you're part of an LLM program where you can choose and pick and have arbitration just at the procedural part and do the rest, finance or whatever, yeah, and do the substantive part, which is, in my view, better that you have a little bit of everything than just focusing on it. But I would advise everybody who wants to do an arbitration course somewhere, even if you don't work in arbitration, if you work in litigation later on, or if you just work internationally, it will help you.
That's a great point.
One word of caution though. What I see often from young, very bright kids, that they work, as trainees with a big law firm, and law firms need them. I need them, but they haven't done their qualification back at home, or any bar admission or any qualification. And they often tell you, well, no, I start with you and I want to continue working and I want to become an associate, because in arbitration, I don't need to be admitted to any bar. Now, I warn these kids and I send them back home until they've qualified and come back, because I've seen it with people also in our generation who started working either in academia or for international organizations and never got what the Germans call the second state exam, the bar qualification, which, is different in any country. But you need a plan B. You need a plan B that if arbitration doesn't work out, you can go back home, do court work, do corporate work, do whatever, become an in-house counsel, but you need what I would call the hunting license of some admission somewhere in the world, because otherwise you might end up getting stuck in a golden cage without having a chance of a plan B. And that would be very sad. And don't wait for the law firms to watch out for you, because they have the cases, they need your work. They will tell you mostly, continue to work, we need you now, don't go back. But that's self-interested. And I hope you take that stern warning. Even though I'm looking for associates, everybody gets that warning, because your career is the rest of your life basically in arbitration, because we all work until we drop dead or we become 95.
It's a good point. Do you see a lot of that? Are there those that have playing the opposite side here? Do you know of colleagues that have not gone back and are now stuck in arbitration because they haven't qualified as a lawyer in a major jurisdiction? Are there those that happens?
It happens, and they're not stuck in arbitration. Being stuck in arbitration and having a career there is nice, but you're stuck in a junior position. Eventually you become too old, too expensive for the law firm that persuaded you to forego your home license, or you're stuck in an arbitral institution, you're stuck in an international organization, you're stuck in a ministry somewhere, and you have nowhere to go. So yes, I've seen them. So
don't do that. But let's try and, I guess, end on a positive note. If Julian or Lucas or Nora, I see in the audience, would like to say something as we close up this this meeting, you're more than welcome to do so. And Stavros, did you have any other thoughts that you wanted to?
And I just want to say that I mentioned Julian's remarkable vision at the very beginning, but now the closing, I want to say and acknowledge all the efforts, the contribution, the wonderful addition that the school was very lucky to have, beginning from the late Professor John Adams, then Lucas Mistelis, then Nora Gallagher, Max Schusser, Debbie De Girolamo, Remy Zerbet, you, Daniel, Anna Howard. I will exclude myself, but without all of these people, with a remarkable knowledge, contribution to the school, the fantastic achievements that they've brought, the school wouldn't have been what it is today. And I'm conscious that I'm a little bit biased, but I would say that all these people have brought the school to being the leading academic institution dedicated to the teaching and the knowledge and research of international arbitration. I think the school is in a very good hands collectively to all these people. We look forward to seeing more alumni. I want to specifically acknowledge also the contribution of the thousands of alumni that have enriched the environment of the school. Special mention also to Maarten Draye, who is here, who is leading the alumni and friends of the School of International Arbitration. Again, remarkable than work that they've done. So many different individuals, many different people from all over the world, they've done the school what it is today. I want to thank again everyone and for participating in this. And I think it's important that we meet more often and we acknowledge the development of the school. That's all I would have to say.
Thank you, Stavros. I second all of that. It's been an amazing experience to join this faculty and an honor. And I wanted to just now, at the end, thank the four of you very much for agreeing to this format and to talking with us today, and quite informative, and learned a lot. And wish you the best, and hope to see you in person very soon. Maybe we can do another one of these alumni events in the near future when everyone can travel and we don't have to stay 2 meters apart from one another. But on that, I think we'll close the session, and thank you again to all of you for joining us today. Thank you very much.
Thanks, everyone.
Thank you.
Thanks.
Thank
Thanks.
you.
I can't wait for the cucumber sandwiches.
Goodbye.
Goodbye.
Bye.
Bye.
Bye-bye.